This presentation will provide you with a description of your rights through several processes within special education that often involve paperwork. These include notices, consent, assessment, surrogate parent appointment, and access to educational records. These are processes required by the laws governing special education procedures. If you haven't already, watch the video The Basics to become familiar with those laws. Let's get started with notices. Written notices must be given when or upon request of specific events that take place in special education. The term prior written notice, or PWN, refers to these notices because they are given prior to a specified action. This written notice is sometimes a separate document, but it is often provided through your child's IEP document itself. Here are the situations when written notices must be given. If the district wants to make a change in your child's identification or eligibility qualifications. Educational placement, such as an STC classroom or non-public school placement. Provision of their free appropriate public education or FAPE. And finally, when it desires to conduct a special education assessment. The school also must provide you with notice in writing when you request or the district denies your request for any changes to your child's offer of FAPE, educational placement, eligibility, or finally request additional assessments. What happens if I ask for my child to be evaluated for special education? You can refer your child for special education services by asking the district to evaluate your child. If you request in writing to have your child evaluated for special ed services, the district must inform you in a written notice of their reasons for accepting or refusing the evaluation within 15 days. They must inform you in your primary language or other mode of communication, unless it is clearly not feasible to do so. When the district gives you the notice, it will include the actions the district wants to take or are refusing to take, an explanation of why they are or are not taking any action, a description of the assessment procedure, record, or report the district used as the basis for taking or not taking action, a statement that you and your child are protected under procedural safeguards, contact information to gain assistance in understanding this process from the NAPA-CELPA or the California Department of Education, a description of other options that the IEP team considered and the reason those options were rejected, and a description of any other reasons the actions by the district are being taken or not being taken. Should the district decide it is appropriate to evaluate your child, the district will determine whether your child is eligible for special education through special education evaluations to which you must give informed written consent. This will usually come to you as and be obtained by the district through a prior written notice form or assessment plan. You are entitled to at least 15 days to come to a decision on giving consent to the plan proposed by the district. You have the right to have your child assessed in all areas of suspected disability. In total, the IDEA recognizes 13 categories of disability that may impact student achievement in school. They are specific learning disability, other health impairment, autism spectrum disorder, emotional disturbance, speech or language impairment, visual impairment including blindness, deafness, hearing impairment, deaf blindness, orthopedic impairment, intellectual disability, traumatic brain injury, and multiple disabilities. A description of your child's disability category can be found on the first page of your child's IEP paperwork. It is important to know that the assessment does not produce a medical diagnosis. It is only an educational evaluation to determine if your child is eligible for special education services under the IDEA. For information about these categories, ask one of the district's special education teachers or our program specialist and school psychologist. Materials and procedures used for the assessments must not be racially, culturally, or sexually discriminatory. The assessment materials and tests must be provided to your child in their primary language or mode of communication, and in the form that will produce the most accurate information telling what your child knows and can do academically, developmentally, and functionally, unless it is clearly not feasible to do so. A single procedure or assessment cannot be the sole method for deciding if your child is eligible for special education services or for forming their FAPE. Once you have given the district informed written consent to carry out the evaluation, the district has 60 days to complete the assessment. The district will then request a meeting to review the assessment results, and if your child was found to be eligible for special education services, to develop an IEP. If you agree to the proposed services and the rest of the IEP, the district must have your informed written consent before providing special education services. If you disagree with the results of the assessment conducted by the school district, you can ask the district to obtain an independent educational assessment or evaluation for your child. You do not have to tell the district why you disagree with the district's assessment. The IEE will be completed by a person qualified to conduct the assessment, but who does not have ties to the district, and it will be completed at no cost to you. You have the right to one IEE for each time the district conducts evaluations with which you disagree. The district must accept or deny the request for any IEE. If the district grants your request for an IEE, it will provide you with a policy on who can conduct the IEE and, at your request, will provide you information about assessors qualified to complete the IEE. Because district's assessment procedures allow in-class observations of your child, if the assessment plan or PWN you gave consent to for your child's evaluation included in-class observations and an IEE is being conducted, the individual completing the IEE must be allowed to make in-class observations as well. If the district wants to move your child to a new school setting and an IEE is taking place, the individual completing the IEE must also be allowed to observe the proposed new school setting. The district can deny your request for an IEE. However, if the district denies your request for an IEE, it must file for due process and prove that its assessments and evaluations were appropriate. If the district is found to be correct and prevails in due process, you still have the right for an IEE, but you will need to pay for it. Regardless of who pays for the assessment, the IEP team must consider any independent assessment you provide to the teams from that point. What if I do not provide consent to an evaluation or an IEP? If the district sends you prior written notice and an assessment plan to conduct an initial or first ever evaluation of your child for special education, and you don't give them consent to begin the evaluation either because you don't want to give them consent or you fail to respond within 15 days, the district may pursue the evaluation through the due process procedures. After any special education evaluation, the district will call an IEP meeting to discuss the assessment results. An IEP meeting must include your child's teacher, a representative of the local education agency, usually a principal, the case manager, usually the special education teacher, and you. If your child qualifies for special education services, but you do not consent to the special education services, the district cannot provide special education or related services, and cannot seek to provide these services to your child through the due process procedure. You do not have to give consent to all the parts of the proposed IEP. Any parts of the IEP you do give consent to must be implemented without delay by the district. The parts you do not agree to will be indicated on the signature page of the IEP and on the notes page. If the district believes the part of the IEP you do not give consent to is necessary to provide your child FAPE, they are required to initiate a due process hearing. Whatever is decided in the hearing is final and legally binding. The district typically will attempt to resolve disagreements with you prior to initiating a due process hearing. The district must reevaluate every student who is eligible for special education at least every 3 years. These IEPs are known as triennials. In the case for reevaluations for special education services only, the reevaluation can proceed without your written consent if the district can show that it has taken multiple measures to obtain your consent. This is typically shown through phone call logs, multiple meeting notices, and emails. The district can pursue this after you have had 15 days to reach a decision on the prior written notice and assessment plan. Can I revoke my consent? You can revoke your consent and remove your child from special education anytime after services have begun being provided. You must notify the district of this in writing. If you decide to do this, the district will provide you with prior written notice of the actions they are taking and stop providing special ed services. May not seek to obtain an agreement to services through mediation or due process. Cannot be held responsible for not providing your child FAPE because of not providing special ed and related services, and is not required to hold an IEP or propose any further IEPs for your child. If you revoke your consent, the district is not required to change your child's educational records that show your child receives special education services. Surrogate parent appointment. The district will assign a child with a disability with a surrogate parent when the parent cannot be found or identified, the child is an unaccompanied homeless youth, or a court finds the child to be without proper care, or if the child is a ward of the state and is referred to special education or already has an IEP. Can I have access to my child's educational records? The district must allow you to inspect and review all of your child's educational records without any unnecessary delay. This can be done at any time, including before your child's IEP or before a due process hearing. If you want access to and copies of your child's educational records, ask either orally or in writing. The district must provide you access and copies within 5 business days.